All right, everybody, we're back with part 3. The courts continually appointed surrogate prosecutors to impersonate criminal defense lawyers. 1. Caleb Paulson. 2. Manny DeCastro. 3. Bo Blown and others before them. See Appendix D. Petitioner moved to withdraw no contest plea within 2 weeks after pleading involuntarily under threats, duress, and coercion to the state's allegations. But I pled no contest, which maintains my innocence, so I have to appeal to maintain my innocence. The petitioner has shown through these several files that he desired to contest all allegations before a jury. Petitioner moved to appeal circuit court's refusal to accept petitioner's withdrawal of no contest plea. Courts appointed Bo Bluen of the Minnehaha County Public Defender's Office to file petitioner's direct appeal. Bo Bluen has since withdrawn his counsel for criminal case appeal and was promoted to the South Dakota State Attorney General's office. So he was acting on behalf of the state and not on behalf of the defendant, as was his duty under statute 16-18. Bo Blown entered a request to be withdrawn from the case due to constitutionally vague conflict of interest. He was working on behalf of the state. That's a fraud. And in retaliation of Gomez's exercising constitutional rights. The courts appointed Minnehaha County Public Advocate's Office Attorney Mark Cady, again, who I sued originally in case 4151. The appeal is pending in the state of South Dakota versus Gomez, CRI 21-7147, for assault on law enforcement and habitual offender statutes. Petitioner communicated clearly, reasonably informing the several court-appointed surrogate prosecutors who customarily impersonate defense counsel that he was claiming self-defense immunity because the law enforcement officers attacked and assaulted Gomez, causing severe pain and causing petitioner to reasonably fear for his life, safety, and liberty, while depriving the petitioner of his property, legal papers, and effects unreasonably and in violation of the Fourth Amendment. Petitioner has raised all federal complaints in adversarial defense to the state's several criminal complaints pro se. I got a new attorney that I believe is with the American Civil Liberties Union, Andrew Connect Law. I got his paper somewhere. Without the Sixth Amendment guarantees and rights of the assistance of counsel for my defense, further depriving the petitioner of my constitutional rights. Judgment as a matter of law in a jury trial. Related motion for a new trial. Conditional ruling. Judgments as a matter of law in general. Summary judgment, Rule 56. I go on to say, petitioner has demonstrated. No, actually, the employees of these government agencies have demonstrated their inability to hold office by consistently failing to uphold and secure the rights guaranteed by the U.S. Constitution to the people, in violation of their oath of office and the Constitution, which they swore an oath to uphold. Instead, creating and following or condoning pattern practices, policy, statutes, laws, official, unofficial customs, or doctrines that contribute to the continued deprivation and violation of the following constitutional rights. First Amendment right to petition and to equally access the courts. Second Amendment right to self-defense. The Second Amendment ain't just about guns. You can defend yourself with anything. It ain't about the guns. But the Fourth Amendment right against unreasonable seizures. The Fifth Amendment right against self-incrimination. The Sixth Amendment right to speedy jury trials and the effective assistance of lawyers. The Seventh Amendment right to civil jury trials. The Eighth and 14th Amendments to due process and equal rights have consistently deprived and criminalized acts consistent with the U.S. Constitution's preamble that all men have certain inherent rights, amongst which include the right to enjoy and defend life and liberty and to acquire and protect property. Petitioner prays the justices liberally construe and draw all reasonably asserted inferences it may draw and consider certiorari. Historical summary of the events leading up to the current petition for writ of certiorari appealed through the 8th Circuit Court of Appeals. Case filed in District Court of South Dakota, Gomez v. Ritter et al. 421-CV-04179 to the 8th Circuit Court of Appeals. All federal cases listed herein had motions to join and consolidate cases into one. The parties in the courts cannot feign surprise or ignorance. Petitioner was charged of second-degree escape by the Circuit Court for the 1st Judicial District of South Dakota County of Union, file number 630-8000-286AO in 2008, Appendix C. The reason they want to ban TikTok is not because China owns it. They want to ban TikTok because we're doing things like this, and they don't want us to peacefully assemble to get a redress of our grievances. It's interference with official acts and constitutional acts. They're interfering with constitutional acts. That's obstruction. Petitioner accepted the plea of guilt after threats, duress, and coercion from Michael J. McGill. See Exhibit 1, document, habeas transcripts, so that I could go to the prison's law library to research and challenge allegations due to the fact that the Union County Jail staff refused to provide law books to the petitioner while in their custody to prepare for trial, depriving petitioner of the right to defend in person against allegations. Speaking to Michael McGill, appointed lawyer, petitioner stated, I'll plead guilty if they grant me a deferred judgment, but I want a deferred judgment in 90 days so I can go to the prison law library and research this and challenge it. Iowa state courts have deferred judgments for sentencing similar to South Dakota's suspended sentences. Attorney Michael J. McGill excitedly responded, South Dakota has suspended executions. 180 days, you will get credit for time served in jail, so less than 6 months you will be out. Plaintiff was transported to South Dakota State Prison and given inmate number 50853. Petitioner researched the law and began to realize and came to the conclusion I was maliciously prosecuted and that Jerry Miller, South Dakota State's attorney, had engaged in prosecutorial misconduct and malicious prosecution, and that the appointed defense lawyer made false and misleading statements unreasonably and rendered defective counsel in violation of 6th Amendment of the Constitution, causing the petitioner to plead guilty to a crime he did not commit. Michael J. McGill elicited a false confession to the crime of second-degree escape on behalf of the state of South Dakota. As a result of petitioner's findings, petitioner filed Gomez versus Davis, Melissa Larson, et al., 0904142 in the United States District Court titled Gomez versus Davis, Appendix B. The appointed judicial officer of the United States District Court dismissed the claim, and I think it was Pearsall, Lawrence Pearsall, during screening. Somewhere on the order dismissing civil suit explained that the petitioner's remedy was a habeas corpus. Petitioner does not have the opinion but did file state habeas Appendix C, because the complaint was liberally construed and implied that the conviction was an invalid conviction and that petitioner was actually innocent of the crime, so I was claiming actual innocence. Thus, that practice violates South Dakota State Constitution's open court clause, depriving the petitioner of remedy for injury in person and reputation. The remedy would have been vacating the judgment of guilt and remanding for a jury trial, which the state and federal courts failed and refused to do, depriving petitioner of rights. In response to the district court's dismissal, petitioner filed a state habeas corpus in the court of conviction. Petitioner filed a handwritten brief and habeas corpus petition in the Union County Court, case file number 63 Civil 090000389AO, Appendix C, Document 2, Findings of Fact. The petition was titled Habeas Corpus Alternate Coram Nobis. See Appendix C, Document 1, Case Summary. A habeas hearing was held on March 1st, 2010. Several weeks after the time for doing so had passed. The deadline dates ascertained by South Dakota laws and statutes governing writs of habeas corpus, Exhibit 1, Document 1, after the time allowed to do so. Petitioner moved for default judgment on his habeas petition pursuant to South Dakota Codified Law 21-27-9.3. Return to writ. Time for filing. Content. The state's attorney of the county in which the writ of habeas corpus was issued shall file a return to the writ within 15 days, unless for good cause additional or less time is granted. The return shall state the true cause or authority for the detention. Exhibit 1. They never did that. So, default judgment. That's what I filed for. Entering a default judgment. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. The clerk didn't do that either. Entering a default judgment by the clerk. If the plaintiff's claim is for a sum certain or a sum that can be made certain by computation, the clerk on the plaintiff's request with an affidavit showing the amount due must enter judgment for that amount and cost against the defendant who has been defaulted for not appearing and who is neither a minor nor an incompetent person. Jerry Miller was not incompetent. He's the South Dakota State prosecutor. By the court. In all other cases, the party must apply to the court for a default judgment. I did that in open court. A default judgment may be entered against a minor or incompetent person only if represented by a general guardian, conservator, or other. If the party against whom a default judgment is sought has appeared personally or by a representative, the party or its representative must be served with written notice of the application at least 7 days before the hearing. The court may conduct hearings or make referrals, preserving any federal statutory right to a jury trial. When to enter or effectuate judgment, it needs to conduct an accounting, determine the amount of damages, establish the truth of any allegation by evidence, or investigate any other matter. When are you going to do that?